Hey everybody, John Skiba here, and it's Thursday night. So we are here doing our weekly discussion on debt collection lawsuits, bankruptcy, all the other terrible things when it comes to debt collection out there. Man, Dave, right out of the chute, thank you for the super chat. Right as we're starting off here tonight, I really appreciate that and appreciate you checking in each week. For those of you who may be new to the live chat, this is something that I do every Thursday night. I am a consumer attorney and a bankruptcy attorney. I practice in the state of Arizona. I generally help people who are dealing with junk debt buyer lawsuits, being sued by credit cards, just a general debt collection lawsuits. I help them in defending themselves against those. I also do a lot of bankruptcy work. And I also do lawsuits against abusive debt collectors, those who violate what's called the Fair Debt Collection Practices Act. I've been thinking about doing some more videos on that. I haven't done a lot of videos on how to respond to collectors who are violating the law, and some of the remedies that you may have as it relates to those. So the way that we do this each week is if you do have a question there in the chat feature on the channel, you can go ahead and put the question in there. I try to get to most of the questions. I don't get to all of them. I will put them on the screen. So if you're comfortable with that, then I can read it and we can discuss it. One thing that my little caveat to everything that I give each and every week is I can't give any legal advice. I'm only licensed to practice law in the state of Arizona. I'm not licensed in any other state. And so because of that, I can only give general information and kind of give you ideas and some strategies. But if you need legal advice, you need to talk to an attorney who's in your state. We've likely never met. I don't know the specific facts of your case. It's something where you need to talk to someone who is close there. So, all right, let's go ahead and get started. All right. Matt's asking, are you answering questions on bankruptcy? Absolutely. So there's a question that you want. It looks like you do have a question right here. Let's go ahead and, okay. Maxed out. So I maxed out all of my credit cards last year, and then I stopped paying in February. Now I owe $85,000 to 13 banks. What should I do? That's a tough one. That's a tough situation. Big time debt owed, a lot of creditors. You know, when I'm looking at the amount of debt, I'm not going to say it's irrelevant because it's obviously relevant. A lot of people don't realize that you don't have to have a certain amount of debt to file bankruptcy. You know, I've had clients who have had $10,000 of debt, but because of their financial situation and their prospects for the future, bankruptcy made sense. I've also had, been on the other end where clients have had $100,000 in credit card debt, but because of their income and their ability to make a living, that they should be able to pay it off or maybe, do some type of debt settlement. A couple things I look at, though, are your ability to pay. So, Matt, there's a large amount of debt there, $85,000, your ability to pay the debt off. And I usually use about a 5-year period. And the reason why I use 5 years is because if you were to file a Chapter 13 bankruptcy, that's where that's the time period it is. So if you think you could get those debts paid off in 5 years, it may be a decent option to avoid bankruptcy would be to looking at how quickly you could pay that off in that 5-year period. Debt settlement in your situation would be tough. One, the dollar amount is high. And my general rule of thumb, unless you have at least 50% to be able to pay in debt settlement, it's going to be tough. Not only that, you have 13 different creditors. When you're doing debt settlement, I always say if you get everybody, if you were to get half of those people on board, great. But then you're still dealing with another 6 or 7 banks that are not on board, and they may force you into bankruptcy. Getting that many creditors is going to be tough. Generally, like in my law practice, I don't take on debt settlement unless it's 2 or 3 creditors kind of thing, because it gets difficult to do. So it is important to know if you qualify for a Chapter 7 bankruptcy, it would likely eliminate or discharge all of that $85,000. I would recommend that you meet with a bankruptcy attorney wherever you live and get some advice, because there's a lot of different factors that go into whether bankruptcy is the best option. It's also good, to get the other options. Sometimes I feel like bankruptcy attorneys, they're just kind of one-trick ponies. They just go, that's all they want to push people in. There are other options, but with the amount of debt, the number of creditors, it's probably leaning more towards a bankruptcy. All right, let's see what Benny has to say. Is it more difficult to defend yourself against the original creditor? Anytime I see a debt collection lawsuit or I meet with a client or someone who's coming into my office, I always break debt collection lawsuits into two groups. Original creditor lawsuits, where it's the actual bank or the credit card company that you had, that they're the ones suing you. And then there's like debt collector or junk debt buyer lawsuits, where it was actually sold to a, excuse me, like a Midland Funding or portfolio recovery, somebody like that. One thing that a lot of people I see get confused is they think that the lawyers that are representing either the original creditor or the debt buyer are the ones who are actually owning the debt. And in most cases, that's not the case. When you're looking at the caption, it'll say like Midland Funding versus John Doe. And then in the upper left-hand corner, it'll have the name of the law firm. They're usually just a hired law firm. Just like my clients, my name's up there. I'm just retained to represent their interests in that. So is it more difficult? It's more difficult in general, even for attorneys, to win original creditor lawsuits. Unless you have a defense like identity theft or something like that, it gets pretty tough because they're going to have the witnesses, they're going to have all the documentation, they're going to be able to prove up their damages. At least you assume they're going to be able to do all these things. Whereas opposed to like a debt collector or a debt buyer, they often don't have all of that information that they need to be able to establish all the elements. And they have to prove not only all the, breach of contract elements, that they have to show there was an agreement, show that you breached it, calculate the damages. A debt buyer then has the added step of having to show that they're the owner of the account. And that's where they often struggle. So that's the long answer for yes, it is more difficult, but it's more difficult for attorneys as well. I generally recommend a settlement strategy when it comes to that. All right, let's see what Margaret has to say. Margaret says, my bankruptcy was dismissed due to non-payment of your Chapter 13. A debt collector for American Express is calling me constantly. What type of settlement would they usually accept? Well, because the bankruptcy was dismissed, that means that the automatic stay, the court order that was in place that stopped collections, is now gone. And so that means that they can do what it is that what they're doing here. They can try to collect on the debt, assuming that it's not outside the statute of limitations. I'm going to tell you, American Express is tough. They are one of the tougher creditors out there. They generally want very high settlements. Usually it's in the 80% range if you're going to do a lump sum. So, if it's a $2,000 debt, they're probably going to want something like $1,800 on something like that. If you're wanting payment plans, it's generally going to have to be something close to the full balance. So, what I always say is put together a plan of what you feel like you can afford, reach out to them and offer that, and wait and see what their counter offer is, and then see if you can find some middle ground on there. But that's kind of a tough spot. So, all right, let's see if we have a lot of bankruptcy questions tonight. All right, this one says, so I had my 341 meeting and I didn't know every year I have to hand over my tax return. Question is, for the unemployment, $10,200 for the CARES Act, do I have to hand that over once it starts? So 341 meeting, for those who are looking at the bankruptcy process, whether it's files Chapter 7, Chapter 13, you have to attend what's called the meeting of the creditors. And sometimes the shorthand for it is 341, because Section 341 of the Bankruptcy Code is what authorizes that meeting. So sometimes we call it the 341 meeting. So the trustee often will tell you and remind you that you have to provide a copy of your tax return as well as a refund. If you're in a Chapter 7, it's usually a prorated portion of the refund has to be turned over to be distributed to your creditors. If you're in a Chapter 13 bankruptcy, most trustees require the entire refund to be turned over. In Arizona, where I practice, there's one trustee that allows you to keep $1,000, and then everything else goes towards your creditors. The question is a good one. So there's the new stimulus payments, the child tax credits are going to be paid out starting July 15th, 2021. And this new stimulus, I just did a video on this earlier in the week, and it's different than the prior ones. The prior stimulus, it was they just deposited money into your account or sent you a check or put money on a card. This one, they're going to calculate how much you're owed, and I believe it's $3,000 for every child you have between the ages of 6 and 17 years old as of December 31st of 2020. And then any child under the age of 6 is $3,600. And so, but instead of just depositing that as a lump sum, what they're going to do is 50% of that is going to be paid out in monthly payments starting on July 15th through December 15th. And then the other 50% is going to be used as a tax credit next year when you file your taxes. So again, these are my long-winded answers of answering this particular question. The United States trustee, the boss in Washington, D.C., has sent out a letter notifying all the Chapter 7 trustees and the Chapter 13 trustees that they are not to administer those funds. They're not to take them. They're not to distribute them to creditors. And not only that, in a Chapter 7, they're not going to count towards the means test in determining if you qualify. This is huge because if you have, I have a lot of kids. I have 6 kids. And so if you have a lot of kids, the amount of money that can be received is huge. And so that may make it so some people wouldn't qualify for Chapter 7 bankruptcy. That's not the case. It's not going to count towards the means test. And in a Chapter 13 case, which is what we think we're talking about here, they're saying the Chapter 13 trustees are not to take those funds and distribute them to creditors. So you should be able to keep those. So hopefully that helps. All right, let's see. Let's see what Twisted has for us today. I've sent the motion to compel arbitration. Is there a chance that when Portfolio Recovery receives their copy, could they stop this process now, or do we have to go to court no matter what? So this has to deal with debt collection lawsuits. Portfolio Recovery Associates is one of the largest debt buyers in the country. And this whole motion to compel arbitration idea, I did a video a while back, and actually I prepared a new online tutorial. I'm going to put that in the things. I have a bunch of little tutorials. I'm going to post it in the chat right now. So if you're watching this, you can see that link and kind of see what those tutorials are all about. But what it is you can request if a debt collector, credit card company, or junk debt buyer has filed a lawsuit against you, in the terms and conditions of that credit card, it likely has an arbitration clause where you can force the matter to go through private arbitration. This is typically done by filing a written motion with the court, asking the court to compel arbitration, push it out of the court system and into the arbitration process. So the question here, is there a chance that once this motion has been filed, if Portfolio Recovery, we call them PRA, receives their copy, could they just stop the process now? It's possible. I mean, you do this long enough, you see that everything's always possible. They probably won't. They may file some kind of objection to it or response to it. But the important thing is, in most jurisdictions, you have the chance to file a reply brief. You can submit, you have a few days after they file the response to reiterate why it should be granted. All right, Eduardo, thank you so much for supporting the channel. I appreciate that. Now let's go over your question. Can a creditor garnish you without judgment against you? Also, I'm named as a JDO and the garnishment is for my wife. Can I speak for her? Great questions. Usually the creditor must have a judgment to be able to garnish you. I know that there are some laws, and particularly in the East Coast, where people will sign, like it's called a confession of judgment or something like that. But usually there has to be some underlying court document, like a judgment, before they can get a garnishment. And not only that, once they get the judgment, they then have to file what's called an application for a writ of garnishment with the court, and get that approved, and then serve that either on your bank or your employer before the garnishment actually goes through. So your name is J. Doe. Now, and I'm going to guess you are in Arizona. Arizona is a community property state. And so a lot of people are confused because they'll see a situation like this where the wife, the spouse, is the named defendant, and then it will say, and J. Doe, John Doe, or Jane Doe spouse. Under Arizona law, a creditor, if they want to be able to collect against the marital community, they must name the spouse. And so when there's a John Doe or a Jane Doe there, that tells me the debt collector is unsure if you're married. And so it's kind of a placeholder that they're putting in there. And so they're putting the J Doe. Now, if your wife is being garnished and you're listed as a J Doe, you cannot speak for her unless you're a lawyer. And so your wife would have to participate in this process as well. But you can also raise objections, particularly if it impacts a marital asset, like your money in the bank account or your home, something that you purchased while you were married. So you can't speak for her, but you both can speak. It brings up another little point. I see a lot of people when they get sued as a married couple and they're representing themselves and they file the initial answer, sometimes only one spouse will sign it. You typically should both sign it so that you don't end up with any type of default. All right. All right. So was wide 35. Thank you. I think you set a new record there with $10 on that. I really appreciate you supporting the channel tonight. All right. Let's see if we can do this. Kind of another tough question here. Can I fire my lawyer and get a new one while in bankruptcy? When you're the attorney-client relationship, it's just a contractual relationship. It's just like hiring anybody else. If the client wants a different attorney, then yes, they can do that. It's something that's going to have to go through the court. There's going to be a motion for the attorney to withdraw. The court's going to have to approve that. There may be a hearing on it. But yeah, I mean, it's just like anything. When I go to the doctor, if I don't want to use that doctor anymore, we can, I can go to a different doctor. So it's no different than that. So, but yes, thank you for supporting the channel. I really appreciate that. All right, let's look at this one from Pipe. On a Chapter 7, do you write a check to the trustee's name when you have liquid assets? I might need a little more information on that, but if there's an asset, so the idea behind a Chapter 7 bankruptcy is that you're going to get most of your credit cards and medical bills. Those are just going to be wiped out. Those are going to be discharged. Trade-off is the court, and typically the trustee, is going to look through your assets that you're disclosing in your documents and look to see if there's any non-exempt assets. These are assets that are not protected by one of the exemption laws in your state. And if there is a non-exempt asset, they can take the asset, liquidate it, and distribute those monies to your creditor. So if you're asking here if you have assets that need to be have been liquidated, or if it's just cash that you have that has to be turned over, typically you do write the check or the transfer the funds directly to the trustee. You're going to want to talk to your attorney or the trustee directly and see how they would like those funds to be distributed, or how you want them to be turned over, because the trustee's job is they take in the funds. So they come through the trustee's office. They will be the ones who distribute it out to their creditors. A lot of people aren't aware the trustee gets a cut out of this. This is the way that the federal government funds the trustee program. As of this video, I believe the trustees get about $60 per case, and then they get a percentage of any of the funds that they collect on behalf of creditors. So, but you want to reach out to that trustee specifically. You'll want to do that. So let me do a follow-up here with Twisted, who asks, a PRA tries to dispute the arbitration. What does one do at that point? So you have filed a motion to compel. They're likely going to file a response. You can file a reply. And then the judge will do one of two things. The judge will set oral argument and have the parties come in and argue their side of the case. Or two, the judge will just issue a written ruling. At the end of the day, you're going to get a written ruling. And so if the judge grants your motion, then it doesn't matter what PRA says, it's going to arbitration. If the judge denies the arbitration ruling, then what you're left with is either proceeding to trial or appealing that ruling. Those are going to be your two options right there. All right. Let me see this one. I'm being sued by Midland. What can I do when I go to court to make sure I win? That is the question that we all have, is how to get this done. I'll post, again, I have that little link to the tutorials that I do that kind of go into a lot of depth. Midland Funding is a junk debt buyer. And like I said, they've got kind of an uphill battle to prove their case. They've got to establish that you had an account with the underlying creditor. They've got to show that you breached it. They've got to show how much is due. They've got to show that they're calculating the amount due. And then they've got to show that they own the debt. And because they don't have access to a lot of the information documentation, that can be a difficult process for them in court. So the first thing you have to do is file a response. 95% of people who are get sued by collection agencies or creditors don't respond. It ends up in a default judgment. So drafting an answer is absolutely the first thing you have to do to avoid that. Because if you don't do that, then it'll be over very quickly. A default judgment will end up being entered. All right, let's see what Robert. I like the profile picture there, Robert. That's sweet. Quick question. Just been assigned for pretrial for Velocity Investments debt collection lawsuit. What should I expect? Well, Robert, I can tell you if you're in the state of Arizona, what to expect. This is going to be a little bit different because, frankly, it's even in Arizona, it's different from court to court. A lot will depend on whether you are in a superior court or a justice court in Arizona. Superior court deals with any case where the amount of dispute is more than $10,000. And justice court, it's anything less than $10,000. The pretrial conference in justice court, you're in Ohio. Okay, so let me tell you this: I've never been to a pretrial conference in Ohio. In general, I can tell you what they are. Is it's really an opportunity for the court to, one, become aware of what the case is about, and two, to set some deadlines. Usually there's discovery deadlines that are set. Sometimes there may even be a trial date set. They may set out any other schedule. Sometimes it's called a scheduling order. In Arizona, sometimes they'll give the parties a chance just to kind of talk because it's really the first time they've gotten together. At least pre-COVID, it was time where we actually met face-to-face and see if there's any kind of middle ground. So that's typically what happens. The one thing I can say in Arizona, if you don't show up, many of the courts enter judgment against you immediately. So again, I said filing the answer is the first most important step. It just goes with the whole theme that showing up is half the battle in these things. You got to be there if the court sets the hearing. So Marcos, thank you. I again appreciate that, as well as is it Pippy super sticker, $3. I appreciate it. All right. Let me see if we have a couple more questions. I may have to cut it a little bit short tonight. I got to pick my wife up from the airport here pretty quick. Let's follow up with some of these bankruptcy questions. After the 341 meeting, the plan goes out to the court. What am I waiting for? Did they let me know if it's been approved? Okay, so this is definitely sounds like a Chapter 13 case. Yes. So once you file a Chapter 13 case, it kind of starts the same way as a Chapter 7. You have the schedules and the statements and a ton of information that you're disclosing there. But you're also, like you're mentioning, you put together a plan. This is a proposal that you're throwing out to the court, to your creditors, to the trustee, for everybody to see how it is, that you're going to pay your creditors. And so once the plan goes out, you've gone to the 341 meeting. Now your creditors, if they want to be involved or receive any kind of money through your plan, they actually have to come file a claim with the court. Sometimes it's called a proof of claim. Basically, this is them saying, we're here, we want to get paid, here's how much we're owed. And there's a deadline set. It's usually 45 days after the date set for the 341 meeting, for the meeting of creditors. And once that deadline is passed, in all the rest of the claims will be barred. And so you'll start to see the claims coming in. And then the trustees will usually, there's two ways that it can happen. In Arizona, what happens is the trustees review everything and they issue what's called a recommendation. And then we will submit a stipulated order to confirm your plan that's signed by all the parties and the judge. In some jurisdictions, they actually have a confirmation hearing where you actually have to go into the court, and all of that will take place actually in live open court before a judge. So it kind of depends on how your jurisdiction handles it. Thank you, Robert and Eduardo. Man, everybody's being super generous tonight. I appreciate that. I'll come back to your question there, Eduardo. Alex is definitely a super fan. He's here, I think, every Thursday, and I appreciate that. Let's do this follow-up question. My wife has a hearing on the garnishment, but we were never sued. Can I participate in the hearing as a John Doe? One, yes, you can participate in the hearing as a John Doe. What I would look, so on the garnishment documents, since you're in Arizona, look on the garnishment documents. There's going to be a case number. And the case number, if it's in justice court, it usually starts with like CC, and then it'll have the year number. If it's in superior court, it'll say CV and have the case, have the year. It may even say TJ. TJ are specifically garnishment cases. But whatever it is, you can call the clerk of the court and they can tell you where the underlying judgment is, whether it was issued out of the justice court, superior court. There has to be a judgment in Arizona for them to do a garnishment like this. If not, they're going to have huge problems, and you can contact me and we'll will sue them under the FDCPA because they can't do the court wouldn't even set the garnishment hearing if there wasn't some kind of underlying as far as the judgment goes. So so that's you can participate, but there's definitely a judgment. You just need to find out where it is. All right. You know what? Let's do this follow-up question. This goes back to the Chapter 13 plan. What happens if I don't agree with the amount of the plan and stuck with it? What happens? I guess, I mean, you should be in someone, I mean, you may not like how much you have to pay, but you had to sign off on the plan before it was submitted if you're the debtor in the Chapter 13 case. If your creditors don't like it, they can raise objections to it. And then that has to be resolved either through the stipulated order confirming your case or through the confirmation hearing. So if it's something where you feel like you can't pay that monthly payment, that's definitely something to communicate with your attorney. And usually to be really proactive about that. Only nationwide, about 30% of the Chapter 13 cases are successfully complete the full 5 years. And I can tell you one of the biggest things is communication with your attorney. The more communication there is with the attorney and saying, hey, I'm drowning here, I can't make this payment, you got a much higher chance of success. All right. Let's see. Couple more here. Let's see. This one here. American Express Global Collections and Strategy Legal Group, actually American Express, the 800 number, the address, nothing matches to the Amex site. Do you know? Well, I can tell you this, that American Express is one of the few credit card companies that does not sell their debt. They handle it in-house. So if the Strategy Legal Group or this Global Collections, those are likely collection agencies that they are using to collect the debt. There's a difference between a credit card company selling the debt to a third party, where they're basically washing their hands with it and saying, we're done with it, as compared to them just hiring out a collection agency to see if they can do it. So my guess is those are both collection agencies that American Express has hired. Usually they hire them for a period of 30 to 90 days to try to collect on that. So, all right. Twisted, thank you again. I appreciate it. Says, of course, guidance has felt like a lifeboat in a dark ocean. Thank you for that. I really appreciate it. I can tell you, you bring up a point that I found, and the main reason why I do these videos is because, when I meet with people in my law practice, the number one thing I see is that there's this panic, mostly because of the unknown. Everyone thinks, they're going to jail or, something like that's going to happen. It's not going to happen. Once you find out what the options are, you're not thrilled about it. You don't want to be in this situation, but you realize that it's usually manageable. There's some type of options, whether you're going to, the main three options to dealing with debt collection lawsuits, that fight it, settle it, or file bankruptcy on it. You have three options, and you're going to live through all of them. I promise. They can be dealt with, and putting together a plan just alleviates a lot of that stress. So, all right, let's do one more. I have a 341 meeting for a Chapter 7 next Wednesday. How long does it take for the discharge if there are assets cash? So typically in a Chapter 7 bankruptcy, the discharge order, and the discharge order is that final order that's entered by the judge that says you're not legally responsible for these debts anymore. The discharge is usually entered somewhere 60 to 90 days after the meeting of creditors. It comes in the mail. Your attorneys generally get it the same day you do, but it's kind of an uneventful, anticlimactic thing. You go through this whole process, and then one day a little letter shows up and it just says discharge at the top. So, but if you have assets, so this is an important little asterisk to that. If you have assets that the trustee is going to distribute, the trustee can keep the case open for a long time. Your case can discharge and you get that, but you're not done just because the discharge has been entered. If the trustee, if there's assets to distribute, it could be a couple months. I've seen it stay open for a year. While the trustee, they're given a lot of latitude to take those assets, sell them or liquidate them, sell whatever they need to do, and then make the distribution to your creditors. So I hope that helps. I appreciate all the support for everybody tonight. And for everybody checking in. I try to do this every Thursday night. And if you do have other questions, I mean, go check out my YouTube channel. I try to, there's, I think, almost 200 videos on there now. And I probably touched on at least part of what a question may be. And then I put in the link there all the tutorials that I have. Those are paid tutorials. I mean, they're a lot more in depth. They have pleadings, things like that. But those are a good source of information as well that can at least point you in the right direction. Again, if you need specific legal advice, just set up a consultation with an attorney. At least get some kind of idea of where you're at, where you're going, and kind of put that plan together, and that will relieve some of that stress. But appreciate everybody checking.